So hello and welcome. For anybody who doesn't know, I'm Eloise Shelton, founder of Vanilla Recruitment. We specialise in recruiting office, accountancy, marketing and HR roles on a permanent and a temporary basis. So thank you for joining us for today's employment law update with Keeley Baigent of KSAB Law. Today we're going to focus on case law developments and what likely changes are going to happen if Labour win the election. So today's session is going to be recorded. I will send you the slides and the presentation next week. So do feel free to ask questions though as we go along in the chat box. I'll keep an eye on the chat box so I can interrupt Keeley and ask your questions for you throughout the session. We're happy for the session to be interactive, but I will pass over to Keeley to have your employment law update. So thank you very much and welcome, Keeley.
Thank you very much, Eloise. So yes, as Eloise said, welcome everyone. And today is an employment law update focusing on just a couple of case law developments and then moving on to look at legislative developments that are going to come in and then what we expect from a Labour government. So I'm going to share my screen and share the slides. So the first case I want to bring your attention to is in the area of sexual harassment. As I said before, there are so many cases at the moment relating to harassment going through the employment tribunals. So I've picked out a couple of those that I think can highlight some points that we should take notice of in dealing with disciplinaries and potential sexual harassment in the workplace. So the first one is this case of Merriman and Bugaba, independent, trading as Project D. And the case is that the Employment Tribunal had to consider claims of whether or not the employee had been sexually harassed by a colleague. The facts of the case are that M was 17 years old at the time and started work at Project D in October 2020 as a donut decorator, which involved finishing donuts prepared by the bakers, one of whom was her colleague called Horn. The tribunal found that 2 months into the job, M and Horn were alone in the canteen when what is referred to as the bear hugging incident occurred. The tribunal found that Mr. Horn put his hands on M's body by bear hugging her and rubbing flour on her before moving his hands downwards and grabbing her bottom as he backed her into the corner of the room. The tribunal was satisfied that Horn said words to the effect of, "I bet your boyfriend wouldn't like that," and M replied, "I bet your missus wouldn't." The panel rejected Horn's denial of having touched M at all. M immediately reported the incident to her supervisor, Miss Dudluch, who described her as extremely distressed. Dudluch discussed formally reporting the matter, but M said she didn't want to get Horn into trouble for what he had done, provided that nothing else happened in the future. The tribunal accepted M's evidence that following the incident, her previously friendly working relationship with Horn then soured, and on occasions, Horn made comments to her, such as calling her a pot washer, saying she was paid less than him, and telling her she needed chewing gum because her breath smelled. The tribunal was satisfied that the souring of the relationship and Horn's treatment of M was because she had rejected his sexual advances. In March 2021, so a few months later, Horn was looking for Miss Keeley, who's another supervisor in the business, and he asked M where she was. M explained she was with another member of staff who was upset and suggested Horn leave her for the time being. Horn insisted he needed to know and shouted at M. She became upset and remarked to another baker that it was lucky she had not reported Horn about the previous incident. Horn then shouted at M, "Come the F-U-C-K here." She was frightened and refused, and he then shouted "F-U-C-K-U" and walked out. Keeley, who had heard Horn shouting, became aware of what had happened and spoke to them both individually. M was told there would be an investigation into the bear hugging incident and subsequent events and was sent home that day on full pay due to her distress, but Horn was also sent home on full pay. The investigation only consisted of speaking to the two of them, so Horn and M, and two other colleagues. The Employment Tribunal decision said, it remains unclear to us why only two members of staff were interviewed or how they were selected. Didluch, who M had spoken with immediately after the bear hugging incident, was not interviewed. The tribunal found that one of the company's directors, Max Poynton, reassured Horn that no further action was going to be taken in relation to the allegations and told Merriman that there was no evidence to substantiate her allegation and she was pressurised to move on. The judgment said this was despite the fact that there was more evidence than there was not to suggest that something had happened, as the claimant had complained of. We find that the respondent simply decided to overlook that and carried out a woefully inadequate investigation. It was, in our view, easier to not make any finding about inappropriate conduct on the part of Mr. Horn than it was to make any positive finding. A month after the swearing incident, M received a letter from Carol Bond, HR manager. It said, I regret to inform you that you have now been allocated all the shifts that we are able to offer you at Project D, and I am writing to advise that we can no longer support your employment as a decorating specialist within the company. And so her employment was terminated. Project D's position was that M was dismissed because there had been a downturn in work following a busy Easter period. The tribunal did not accept that, citing press reports and emails that indicated otherwise. An email from Bond days after the swearing incident read, Project D has grown at such a rate that this has been challenging to increase donut production and manage the bakery environment at the same time. As you are aware, we are currently looking to employ new team members to take the pressure off existing colleagues. So M brought claims of sexual harassment, less favourable treatment for rejecting or submitting to harassment, and victimisation. So had there been sexual harassment or less favourable treatment for rejecting or submitting to the harassment? Looking then at the relevant definitions, which are detailed on the slide, a person sexually harasses another if they engage in unwanted conduct of a sexual nature and the conduct has the purpose or effect of creating an intimidating, hostile, degrading or offensive environment for that person. And that's section 26(2) of the Equality Act. A person also harasses another if they engage in unwanted conduct of a sexual nature. The conduct has the purpose or effect of creating an intimidating, hostile, degrading or offensive environment for that person. And because of that person's rejection of or submission to the conduct, the other person treats them less favourably. So what do you think in this case? And I'm going to read to you what the Employment Tribunal's findings were. So the Employment Tribunal said, we begin with whether Mr. Horn harassed the claimant contrary to that section 26(2). We have found as a fact that Mr. Horn bear hugged the claimant, backed her into a corner and grabbed her bottom. Given the fact that involved touching the claimant's bottom and what had been said by Mr. Horn when he did so, we are satisfied that was conduct of a sexual nature. It involved touching the claimant in an intimate place. We must then consider the question of whether the conduct was unwanted. We have no hesitation in finding that it was. Whether the claimant had had what has been described as a flirty banter or not, there was nothing that could possibly have invited Mr. Horn to grab her in the way he did. We are more than satisfied that the conduct was not invited or encouraged and that it was entirely unwanted. And just on that point, as we've looked at other cases on this, in a large amount of sexual harassment and general harassment cases, a response or a defence may be run on the basis of, oh, it was just banter and it was two-way banter. And that comes up commonly in these cases. In this case as well, but the tribunal found that there may have been some banter, but this particular act was unwanted. We then turn to consider whether the conduct had the effect or purpose of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for her. We have no hesitation in concluding that the effect was that it did. The claimant's evidence was that it made her feel intimidated and uncomfortable, and given the circumstances and Miss Dudlutch's evidence as to how she had presented when she told her about the incident, we are entirely satisfied that it did. It follows that the incident amounted to an act of harassment. We then turn to the complaints of harassment contrary to section 26(3), and begin with whether Mr. Horn called the claimant a pot washer, made comments about her wages being less than his, and said in terms that she needed to chew gum because her breath smelled. And we have found as a fact that Mr. Horn did all of those things. As we have already found section 26(2) to be made out, that leaves the question under section 26(3 as to whether what Mr. Horn did in this respect was because the claimant had rejected his conduct in respect of the incident. We are satisfied from the claimant's evidence that it was. Prior to the incident, things were harmonious between the claimant and Mr. Horn, and we accept her evidence that after that point, there was a shift in regard to the way that he treated her and the inappropriate comments that he made toward her began. The only thing that had changed between them at this point and the previous harmonious working relationship was the claimant's rejection of Mr. Horn's advances during the incident. Accordingly, we are satisfied that the comments which were made by the claimant, made about the claimant by Mr. Horn amounted to harassment within section 26(3). In respect of the harassment complaints, that then leaves the question of whether Mr. Horn shouted at the claimant on 28th of March 2021, belittled her and called her names and shouted and swore at her. And as we have set out above, we accept that Mr. Horn shouted words to the claimant and swore at her, and that she refused because she was frightened. And when she refused because she was frightened, he swore at her again. And we find that those are further acts of harassment. So the tribunal upheld both harassment claims. Looking then at her claim of victimisation, that definition of victimisation is up on the slide. A person victimises another person if they subject that other person to a detriment for doing a protected act. And a protected act includes making an allegation that the person has contravened the Equality Act. So again, what do you think in this case? The question is, was she treated detrimentally because she raised an allegation that she had been sexually harassed? The Employment Tribunal held that the claimant received detrimental treatment both because of the swearing incident, but also because of the employer's failure to conduct a proper and fair investigation. So they were both held to be acts of victimisation. In addition, the act of dismissal was also held to be an act of victimisation. So in that respect, the tribunal held that the claimant had been dismissed because of the fact that she had raised an allegation of sexual harassment. So all her claims were upheld. As to the issue of whether we'll move on to remedy, because all her claims succeeded. The respondent asserted that the dismissal was because of a downturn in work, and because of the evidence that contradicted that, the tribunal held that they believed she'd been dismissed because of this allegation she raised of sexual harassment. So what was she awarded in this case? At a remedy hearing, she was awarded £31,400, and she was a relatively low-paid employee. This comprised financial losses of only £6,000, but an injury to feelings award of £25,400. So, I mean, that is quite a high award, but obviously when you look at what has occurred, there was that first incident of harassment, then there was the second where she was harassed because she rejected his advances, and then thirdly, the dismissal, which was held to be an act of victimisation. In calculating the injury to feelings award, the tribunal noted that the events had a profound effect on M, including causing her to go from being a bubbly, vivacious girl to a shell of her former self. The Employment Tribunal noted that the effects only began to resolve themselves almost 3 years after the events, with Miss M having to take medication for her mental health and having trauma coaching. The Employment Tribunal said that the employer had protected the male colleague rather than Miss M, which was compounded by her dismissal because she raised the fact that she'd been sexually assaulted. At the time of the incident, Miss M was only 17 and 18 years old, and so was vulnerable by reason of her age. The experiences had led Miss M to have a lack of trust in men and authority figures, which had blighted her ability to obtain employment and trust new employers. So hence the reason why the injury to feelings award was relatively high. Just looking then at another case in the area again of sexual harassment, it's the case of HRHuddle and Bellevue School. The facts of this case are that Mr. P worked at Bellevue School in Ealing in West London and was dismissed in 2020 after lying about his summer absence to take a summer holiday in Croatia. The school had closed to most students from March 2020 due to the COVID pandemic, and a rota was created for staff attendance at the school. Irrespective of this rota, the head teacher had advised that all staff would be required on site in the final week of term in July. Mr. P asked the head, Mrs. O'Shea, if he could take his holidays early so he could visit his parents in Georgia for his birthday, but this was declined as he had previously failed to return on time from another period of special leave. Later, on the day of the request, the head discovered that Mr. P had gone to the pub for what was regarded as leaving drinks with colleagues, announced he was going on a European tour with his best friend the next day. Upon hearing this, the head requested to see him with a trade union representative the next week, but Mr. P phoned the school to say he could not attend because he was suffering from COVID symptoms and would be self-isolating. Mr. P then went off sick at the start of the next term with sick notes stating he had work-related stress. He did not attend an investigatory meeting in October 2020 and submitted further evidence that he was suffering from stress and did not have the capacity to be involved with anything work-related. In the November, he was sent a letter detailing allegations of gross misconduct and that he was to attend a disciplinary meeting the following week. The accusation centred around misrepresented reason for absence in that he had embarked on a European trip rather than a visit to his parents, and that he had abused the trust of the leadership team by giving false information relating to the reasons for absence. It was shortly after this letter that Mr. P then submitted a complaint of sexual harassment against the head teacher. He detailed an incident 10 years before in 2010 when he said that he'd been the subject of unwanted sexual advances by the head teacher. He also referred to year-on-year incidents at staff meetings, but failed to specify these. He also claimed that he'd been held back from professional development. The tribunal heard accusations that the head teacher had sexually harassed P on 7 occasions between 2017 and 2019, including by a comment that he looked fit in his Speedos. The ET said that there were other unspecified incidents in which the head teacher supposedly made unwanted sexual advances to the claimant, and finally he contended that the head teacher said in June 2020 that she wanted him to take her to meet his parents. After P's disciplinary, he was told by letter that he was going to be dismissed, and this would be effective from the 4th of December 2020, although the letter was mistakenly sent out on the 15th, making that the effective date of termination. P appealed the disciplinary outcome, claiming the investigation had not been fair, raising discrepancy in the dates of his dismissal and that he was owed wages, and that he had provided a landlord statement to show he was at home on the dates in question. The appeal was not upheld. So P then brings claims of unfair dismissal and sexual harassment. What do you think happened? Well, as can be seen, the unfair dismissal claim was upheld, and you may gasp at that, as I did when I first read this. In his claim of unfair dismissal, the tribunal found in his favour, claiming that the school had already drawn a conclusion about P's behaviour and that it was clear Mr. P was never going to get a fair determination of his complaint. It stated that the head teacher had already made up her mind about the claimant's guilt before an investigation was conducted. In the judgment, the content of the investigation report is referred to, which appeared to make findings of fact that the claimant was guilty of the conduct. So, for example, it said things like, the head teacher discovered the real reason for your absence, rather than raising it as a question or a potential or an allegation. It was stated as a fact. The ET stated that the investigation report was short, inaccurate, and hopelessly biased. It further stated that the language was condemnatory of the claimant. The ET stated the person who conducted the investigation had not undertaken this with an open mind. She built a case against the claimant and discounted anything that might not suit the claimant's dismissal. Such a biased investigation was a breach of the ACAS Code of Practice. The Employment Tribunal said that such an investigation report might not have mattered too much if there were robust disciplining officers. But here, the disciplinary chair and the other school governor were distinctly not robust. One was unimpressive as a witness and appeared totally out of her depth throughout the process. She also did not have any training in that role. She did not have an inquiring or challenging approach. In fact, she did nothing other than accept this flawed report. In effect, the Employment Tribunal believed that the outcome of the disciplinary procedure was predetermined. So the Employment Tribunal held that an unfair procedure had been adopted in dismissing the claimant. It stated that the procedure was outside the procedure that a reasonable employer in those circumstances would have conducted. So it fell outside the reasonable band of responses. The Employment Tribunal determined that the respondent should have obtained more comprehensive medical evidence and that P should have been referred back to occupational health during the disciplinary procedure and at the investigation stage. It held that the procedure had been rushed through because a decision had already been made. The Employment Tribunal were also concerned about the head teacher's involvement in the disciplinary procedure. It said she had her fingerprints all over this process. In effect, the Employment Tribunal said that the head teacher had directed both the investigation officer and the chair of the disciplinary hearing. The Employment Tribunal further criticised the respondent in that there had been no consideration of any mitigating factors in the dismissal letter. There appeared to be no consideration of the landlord's letter, for example, at the appeal stage. With regards to the appeal, this was conducted as a review rather than a rehearing, and therefore it failed to cure any of the defects of the disciplinary process. So, Mr. P was therefore awarded compensation for unfair dismissal. The Employment Tribunal then went on to consider whether or not the compensation should be reduced. Firstly, under the case of Polkey. So if we cast our minds back in previous updates, Polkey being the principle, under the case of Polkey, the principle of even if a fair procedure had been followed, the employee would have been dismissed in any case. So in effect, the compensation is reduced to take account of that. So the tribunal looked at that first. With regard to this, the Employment Tribunal said the following: in respect of a Polkey deduction, there was no minor defect in the respondent's application of its dismissal procedures. Its defects were fundamental and profound. Some processes adopted by the employer are so unfair and so fundamentally flawed that it is impossible to formulate the hypothetical question of what would the percentage chance the employee had of still being dismissed, even if the correct procedure had been followed. If the disciplinary investigation had some merit to it, then we may have accepted the application of Polkey. However, the circumstance of this case was that the respondent wanted rid of this employee, and irrespective of his health or the other evidence or mitigation, the respondents were determined to get rid of him. There were at least 2 human resources representatives involved, so we cannot conclude that the defaults were inadvertent or insignificant. No reasonable employer would have adopted this approach. Consequently, we make no Polkey deduction. And I find that astonishing, that in this type of case, no Polkey deduction was made. Saying that, the tribunal then went on to consider contributory fault deductions or reductions to compensation because of the claimant's fault or conduct that contributed to his dismissal. On this, the Employment Tribunal stated, in his witness statement, the claimant said the requirement for him to attend work for the last week of term was unfair and outside his contractual obligation. The claimant said he needed notice, which was a silly argument, as the head teacher did not need to give him notice to do his job in the school. It was a reasonable request to be in school for the last week of term. He lied to the head teacher about going to Georgia. We determined that he was never going to attend work for that last week. The claimant had a pre-booked holiday, as evidenced by his boarding card, to Croatia. We determined he lied about his COVID sickness absence, as this was never corroborated with any test results or sick note or other evidence. And having heard this evidence, we now view him as a dishonest person, both because of the lies he told at the time and more shockingly in respect of the deliberate creation of misleading evidence. In evidence, the dismissing officer said that the claimant's dismissal was not inevitable during the disciplinary procedure. She said that if he had been contrite and honest, then the result would have been different. But the claimant showed no insight, and there was no recognition that he had done anything wrong. The claimant was guilty of blameworthy conduct. His absence was serious, but not necessarily overwhelming. It is his lies that have disturbed us most. We are resolved to make a substantial deduction on the basis of his blameworthy conduct. The claimant's misconduct clearly contributed to his dismissal. We thought strongly about making 100% deduction, but that would have been disproportionate, bearing in mind our criticisms of the respondent's behaviour. We were resolved to reduce both the claimant's basic award and compensatory award by 70%, i.e. he will only get 30% of the compensation we assess that he is due for unfair dismissal, and this is on the basis that we expect this figure to be fairly modest. So he still got awarded 30%. On the sexual harassment argument, the claimant actually won. The judge said both language and attitudes of colleagues change. So both language and attitudes to colleagues change over time, and comments that might have been prevalent and acceptable in a workplace 30 or 40 years ago are no longer justifiable or tolerated. The judge further stated in his judgment Similar comments made by a senior man, particularly if older, are generally regarded as unacceptable if directed towards a junior or younger female. And perhaps belatedly, such comments made by a female head teacher towards a younger teaching assistant should now similarly be regarded as unacceptable. But the judge also stated, that said, the claimant did not pursue these matters promptly because we determined that he did not regard the head teacher's behaviour as either particularly serious or worrying, which will make any award modest. Whilst it is important to recognise and mark occurrences of sexual harassment, we do so in this particular case, cognizant that compensation for these events fall on the more modest side of the scale. So, what do we conclude from those two cases? I think it's really important that we take note that even where an employee appears guilty of something and all the evidence does point in that direction, we still conduct a robust and reasonable procedure, and we don't make conclusions right at the beginning of process, and we don't and we conduct these processes with an open mind, and there are separate people dealing with each stage, and they're not influencing the opinions of other people during the process, because all of that really could have been avoided had the investigation been conducted in a better and more reasonable way. Also, you know, this banter that may go on in the workplace that we may be seen to be banter or trivial, or we need to be on it. We need to be making sure that we're training and we're making our policies on equal opportunities robust, and teaching our staff that those kinds of comments, even though they may be mutual and tolerated, are not acceptable. I'm going to jump then to legislative changes. So there's a couple I want to mention because they will come in. They might have changes made to them, but they will come in. So the first one relates to the data subject access requests and the changes around the law in that area. I alerted you to new guidance published by the ICO last year for employers on responding to data subject access requests. The code highlighted some of the common misunderstandings that organisations have with regards to data subject access requests. For example, some employers are unaware that requests can be submitted informally, and they do not need to be labelled or titled data subject access requests to make them a legitimate request and falling under the legislation. New stats from the Information Commissioner's Office are that they received more than 15,300 complaints last year, that being a 13.5% increase from the 2022 figures. And this is over organisations' failures to comply with their obligations around data subject access requests. As we all know, individuals can submit these requests to employers. We may get them from former employees, and they may be significant in terms of the time and the effort that we have to put into them to deal with them. And we may feel that on many occasions it's a bit of a fishing expedition. It's to try and obtain documents pre-disclosure in tribunal proceedings, or it's to try and facilitate a settlement. Following Brexit, the government proposed to amend the UK data protection law in a shift away from the GDPR with the Data Protection and Digital Information Bill. The bill had been expected to be passed later this year in October, but it hasn't been included in the pre-election publications in May. So it would have to be reintroduced by the government in place in the next Parliament. if it so desires to press on with it. It's expected to make compliance with data subject access requests less burdensome for businesses. Of particular interest to employers under the draft bill, it would have been easier for organisations to reject or charge a fee for vexatious subject access requests. And this was going to be quite a welcome thing for employers. We'll have to see if it comes in. My view is it will, but whether it's October or a later date, we'll have to see. The other one that I want to mention is this protection from harassment legislation. I again mentioned it in a previous update, and it's the Worker Protection Act 2023, and this will be coming into force in October 2024. It may be in its current form. If Labour get in, they're saying that they're going to strengthen that legislation. In its current form, the legislation will amend the Equality Act to introduce a duty on employers to take reasonable steps to prevent sexual harassment of their employees. And this has come in because of the traffic going through the employment tribunals of harassment cases. So this means that employers will have a new proactive duty to prevent sexual harassment in the workplace. And the aim of this legislation is to place greater responsibility on employers to make their workplaces safer for all staff. The reasonable steps that an employer is going to be expected to take will include training and to have working policies, equal opportunities policies in place. And that is essential to start in October, because both governments, either one, well, Labour, if it gets in, will have pledged to continue with this. So on the 9th of May, Labour Deputy Leader Angela Rayner unveiled new plans to crack down on sexual harassment generally, but also of interns and volunteers in the workplace, pledging to give women the best start in working life. In part of the speech released in advance, Rayner said sexual harassment remains rife in workplaces across Britain. For any employee, but especially interns and volunteers, experiencing sexual harassment can destroy confidence and ruin early careers. The next Labour government will strengthen the legal duty requiring employees to take steps to prevent sexual harassment at work, and will ensure this duty applies to contracted interns and volunteers as well as employees. My message to working women is clear. With our new deal for working people, a Labour government will have your back. So that will come in its current form or strengthened. The other piece of legislation that's due to come into force on the 18th of July, unless it's repealed, relates to the statutory code to deter fire and rehire practices. And dismissal and re-engagement is fire and rehire. So the practice is if an employer is wishing to facilitate a change in employees' terms and conditions of employment, they may look to dismiss an employee from their employment and under their current terms and conditions, and offer re-engagement on the new, less favourable, usually, terms. And that's what's called the fire and rehire principle or practice. It has become more common in recent years, and you may have seen cases surrounding this practice in the press, and hence the code. So in the new proposed code of practice, it details how an employer must behave when attempting to make changes to employees' terms and conditions of employment. The employment tribunals will have the power to apply an uplift of up to 25% of an employee's compensation if an employer unreasonably fails to comply with the code. The Business Minister, Kevin Hollerake, said, our new code will crack down on employers mistreating employees and sets out how they should behave when changing an employee's contract. This announcement shows we are taking action to tackle fire and rehire practices by balancing protections for workers with business flexibility. Employers code explore alternatives to dismissal and re-engagement, they'll have to go through a public consultation process to try and obtain agreement for looking at dismissals. They will have to have meaningful discussions with employees and if applicable trade unions before going down the dismissal route. And the code makes it very clear to employers they must not use threats of dismissal to pressure employees into accepting new terms. And they should also not raise the prospect of dismissal unreasonably early or threaten dismissal where it is not envisaged. So as I say, Labour has described the code as inadequate and says they will strengthen it if they succeed in government. In May, Labour's shadow chancellor insisted fire and rehire practices should, under a Labour government, be banned in general, but that there had to be some exceptions. And Rachel Reeves told the BBC, "We will end fire and rehire, but when a company is facing bankruptcy and there is no alternative, they will have to consult with their workers and with their trade unions. Those are very, very limited circumstances." So it appears if Labour get in, they will strengthen that code and they will not permit fire and rehire practices unless there is an insolvency situation. But let's move on then to the report. And I must say, if Labour do get in tomorrow, I think we're all going to be very busy over the next few years. So there's no concerns about not being in a job, I don't think. So the Labour Party proposes wide-ranging reforms to employment law. On the 13th of June of this year, the Labour Party published its manifesto, and the manifesto confirms that a Labour government would implement in full Labour's plan to make work pay, delivering a new deal for working people, which I'll refer to as New Deal, and would introduce legislation, an employment rights bill, reforming employment law within 100 days of entering office. So looking then at some of the employment law proposals, and starting with Labour's proposal to introduce day one employment rights. So the New Deal states that basic individual rights will be provided from day one for all workers, ending the current arbitrary system that leaves workers waiting up to 2 years to access basic rights of protection against unfair dismissal, parental leave and sick pay. So with regards to sick pay, the proposal is that there will no longer be 3 waiting days, and SSP will kick in from day one. With regards to parental leave, so this being the leave that is 18 weeks in total of unpaid leave to be taken in blocks of up to 4 weeks each year until the child reaches 18. So that's the right. Currently, there is a qualifying period for parental leave of 1 year, and the proposal is that 1 year qualifying period is axed, and so from day one, people are entitled to take unpaid parental leave, let's say 4 weeks, up to 4 weeks in each year, up to a cap of 18 weeks over the course of the years until the child reaches their 18th birthday. With regards to unfair dismissal, and this is the big one really, as we know under current rules, UK employees can only bring a claim of ordinary unfair dismissal if they've been employed for a minimum of 2 years. There are, of course, exceptional circumstances to that, the automatically unfair reasons, automatically unfair dismissals. But the general position is 2 years service before they are able to bring an unfair dismissal claim against their employer. This period is going to be reduced to a day one of employment right under Labour's proposals. However, there have been some movement on that more recently. It was subsequently reported by Labour that they do not intend to prevent employers from applying probationary periods and dismissing employees during those periods. So therefore, commentators speculate that the probationary periods for performance will still apply under Labour. It's unknown how long such periods will be permitted to operate. It may be a compromise. Example like Ireland's level of protection, people are saying that's 6 to 12 months with unfair dismissal protection from 12 months continuous service. That might be where the UK ends up. So we might be going back to, and I couldn't remember how many years ago it was, when we had a 12-month, 1 year qualifying period. It was a few years ago, wasn't it? If you're as old as me and can remember that far back. So we might be going back to that situation. It will be within a probationary period, according to the commentators and what Labour's released. So, as I say, it's going to be a day one right, but if there is a probationary period, a dismissal within the probationary period may well be permitted. And it might be that the probationary period is 6 to 12 months. We'll have to wait and see. Well, what are people saying about this? These proposed changes signal a significant shift in the employment law landscape, and if implemented as they currently stand, would be something of a shock to many employers. Dismissals before 2 years service tend to be more straightforward under the present regime, but under the proposals, employers will much more frequently have to implement proper procedures and a more formal process to dismiss. Employers will likely have to implement time and resource intensive processes at a scale that is radically different to what they currently do within that 2 year period. This could inevitably lead also to spikes in legal claims. So the traffic in employment tribunals increases even more. And how will the tribunals cope? Because there's such a backlog still. With more claims, it's really questionable whether or not the tribunals have got the resources to deal with those. The proposals could also lead to a more agile workforce, people not sticking around to acquire statutory protection rights after 2 years, and therefore moving around, which could be an advantage and a disadvantage. At the present time, the proposal can only be seen with a large number of difficulties attached to it, but we shall see. The next proposal then relates to flexible working. In the New Deal, Labour have said that they would make flexible working the default for all employees from day one, except where it's not reasonably feasible. It suggests that a Labour government would build on the changes to the framework for flexible working recently introduced by the current government to ensure that flexibility is a genuine default. You'll recall that the right to request flexible working became a day one right back in April, and Labour is just focusing on expanding and extending all these flexible working rights. Previously, the New Deal Green Paper suggested that Labour would support small and medium-sized businesses to adapt to these flexible working practices and increase the uptake of flexible working, but we'll see. Again, implementation of the extension of flexible working rights have been stated by some commentators to be very difficult for small to medium-sized businesses to cope with due to the associated costs and the cover issues that these may lead to. Another of Labour's proposals relates to ending the one-sided flexibility in the employment relationship. In its New Deal, Labour commits to ending one-sided flexibility and to ensure that all jobs provide a baseline level of security and predictability by, firstly, banning exploitative 0 hours contracts, and secondly, ensuring that workers have the right to a contract that reflects the number of hours they regularly work based on a 12-week reference period, and reasonable notice of any change in shifts or working time with compensation that is proportionate to the notice given for any shifts cancelled or curtailed. So that is pretty significant, really, this ban on 0 hours contracts, although the introduction of the word exploitative is noted by commentators. They will continue workers to have the right to paid overtime rates, and employers will still be able to offer fixed term contracts, including those for seasonal work, because that's the worry, isn't it? You know, that people work through a season, say in the hospitality sector or similar, and then they have to be offered they have to be offered a permanent contract based on the hours they've worked in the previous 12 weeks, when the work isn't there. So that's going to be covered off by potential fixed term seasonal contracts, which are still permitted. Previously, Angela Rayner, in her speech at the Labour Party conference in October last year, committed to implementing a full ban on 0 hours contracts. You probably saw this in the press. This was also provided in the New Deal Green Paper, which confirmed that anyone working regular hours for 12 weeks or more would be entitled to a contract to reflect the regular hours worked. So at that point, it was very much a ban on 0 hours contracts. However, in May, Labour backtracked and introduced this word of exploitative 0 hours contracts. And as part of these revised plans, while employers would still be required to offer a contract based on regular hours worked over the previous 12 weeks, a worker would be entitled to opt out and say, no, thank you, I don't want that. I want to stay on my 0 hours contract, thanks. But it's going to be very much the worker or the employee saying that, and the employee still has to make that offer of the contract. On 7th of May, Rachel Reeves, Shadow Chancellor, confirmed that exploitative 0 hours contracts would be outlawed, but after 12 weeks, Labour would allow people with regular hours to move away from a 0 hours contract. If someone did want to stay on a 0 hours contract, however, they would have the freedom to do so. So I said, putting the decision in the court of the worker or employee rather than the employer. A further change in May from the original proposals concerns the payments workers would be entitled to for cancelled shifts. So at the moment, 0 hours, if a shift is cancelled, they don't get paid. Labour had said workers were to be paid in full for shifts cancelled without suitable notice. But now, under Making Work Pay, they need only receive compensation that is proportionate to the notice given for any cancelled or curtailed shift. So they backtracked slightly on that. Next proposal then is to extend and enhance family-friendly rights. We've got an extension of flexible work, but we've also got an extension of family-friendly rights. The New Deal states parental leave will become a day one right. We've touched on that before. Also, maternity and paternity leave would be extended, and the shared parental leave framework would be urgently reviewed. It would be made unlawful to dismiss a woman during pregnancy or within 6 months of her return to work, except in specified circumstances. Entitlement to bereavement leave would be clarified and extended to all workers. And implementation of the legislation for unpaid carers leave, which was introduced in April, which we went through, would be reviewed, and the introduction of paid carers leave would be examined, being mindful of the impact of any changes on small employers. So paid carers leave. On 19th of June, Rachel Reeves refused to commit to increasing statutory maternity pay, but promised to review parental leave, which would become a day one right within a year of the election. We have looked at this dismissal and re-engagement code that comes in. Under Labour, they would be committed to strengthen that. And as I said before, it can only apply, dismissal and re-engagement would only apply in an emergency situation under Labour. That code is due to be coming into force on the 18th of July, but it's likely that that is going to be extended by Labour if they get in. The next proposal, this is an interesting one, relates to employment status. So one of Labour's main proposals in its New Deal is a plan to create a single status of worker. So at the moment, we have three status. We have employees with full employment and statutory protection rights. We have workers, which have less rights, and there's a bit more give and take, a bit more freedom between the employer and the worker. And then we have people who are in business on their own account, truly self-employed individuals. And there's been a lot of litigation in the past few years about basically about whether or not anyone fits into these categories. So workers may say we're actually employees, so we've got unfair dismissal rights. And self-employed, like the taxi drivers have said, we're actually workers and so we're due holiday pay. So there has been a lot of litigation on status in the past. Labour's proposal is to have to reclassify and have two statuses. So one being a worker, and that would encompass workers and employees. The single status, they would have the full suite of employment rights. And then under the proposal, all individuals with the worker status, regardless of sector, wage, or type of contract, would be given the same rights and protections, including sick pay, holiday pay, parental leave, protection from unfair dismissal, right to a redundancy payment. Labour would also clamp down on bogus self-employment. Labour's view is that the three-tier system of employment status at the moment has caused a lot of difficulties, which it has, to be fair, and complexities. And some people, don't know whether they're a worker or an employee, and their employers don't know whether they're a worker or an employee. So it has caused a lot of difficulties. The New Deal states that Labour will move towards a single status of worker and transition towards a simpler two-part framework for employment status. And to do this, Labour will consult in detail with everyone about it, and they will evaluate the way flexibility of worker status is used and understood across the workforce. Well, I don't think it's really understood very well at all. But anyway, that's what they're going to do. And then the New Deal provides that Labour would strengthen rights and protections to help self-employed workers, including the right to a written contract, action to tackle late payments, and by extending health and safety protections to self-employed individuals. Also, another proposal is the creation of a single enforcement agency. So some of these pressures that the tribunals are under, or going to be under even more pressures if all of this comes in, will hopefully be alleviated by the creation of a single enforcement body to enforce workers' rights. The New Deal states the new body will be given extensive powers to inspect workplaces and bring prosecutions and civil proceedings on workers' behalf relating to minimum wage violations, worker exploitation, and discriminatory practices. This body will need to have the powers it needs to undertake targeted and proactive enforcement work and bring civil proceedings upholding employment rights. And Angela Rayner said it will be called, it's called a Fair Work Agency. Next proposal relates to employment tribunal proceedings, and another significant one for us, confirming that the time limit to bring an employment tribunal claim will be increased from 3 months to 6 months. In addition, the New Deal Green Paper suggested there would be tougher penalties on employers who break the law or fail to comply with tribunal orders, and this would include introducing personal liability for company directors. And also any caps, on compensation payable to workers following an employer's breach of the law would be removed. And therefore it appears that the statutory cap on unfair dismissal compensation and also on a week's pay in calculating some compensation will be removed. What could this do? Well, it could inevitably lead to more claims. So as we know, the current cap on unfair dismissal compensation, a compensatory award, is 12 months gross pay, or around £115,000, whichever is the lower amount. That the proposal is to remove that cap, which could obviously encourage more claims and also result in less claims being resolved going to a hearing. Next proposal relates to redundancy. New Deal says that Labour would strengthen redundancy rights and protections, for example, by ensuring the right to redundancy consultation is determined across the business as a whole, rather than the establishment or the place of work. And that's in relation to collective consultation. So I'm not going to go into detail about that, but there's some changes afoot potentially in the redundancy in determining numbers involved across the business. Right to disconnect is another proposal. This is an interesting one. The New Deal states that a new right to switch off would be introduced, providing workers the right to disconnect from work outside of working hours and not be contacted by their employer. And this would be done following similar models that are in place in Ireland and Belgium, I believe, and France. So there may well be penalties if employers do try and contact their employees out of hours. Statutory sick pay is the other proposal, and in respect of statutory sick pay, Labour government would strengthen statutory sick pay, remove the lower earnings limit to make it available to all workers, and remove the waiting period, which we've looked at. Labour would also ensure the new system provides fair earnings replacement for people earning below the current rate of SSP. So, an increase in SSP potentially, making it available to everybody. TUPE proposals to strengthen the existing rights and protections for workers subject to TUPE processes. And then a proposal in relation to wages. So in relation to national minimum wage, Labour proposes to ensure that the national minimum wage is a real living wage that people can live on. So even though it's gone up this year quite significantly, potentially it will go up again quite significantly. And to achieve this, the proposal says that the remit of the Low Pay Commission, which reviews and makes recommendations on the national minimum wage, would be expanded to ensure that the national minimum wage takes into account increases in the cost of living. The discriminatory age bands would be removed to ensure every adult worker benefits. And the single enforcement body in HMRC will be provided with enforcement powers, including penalties for non-compliance. Also sticking with wages, but tips. It's not in there actually, is it? Yeah, tips, there we are. Hospitality workers will receive their tips in full. That's the proposal under Labour. They will also decide how tips are allocated. In the area of grievances, Labour states that they will enable employees to collectively raise grievances about conduct in their workplace with ACAS. And this will be in line with the existing code for individual grievances. So I think what that's implying is that, because at the moment there is no practice, there is no ACAS code of practice that deals with group grievances. So I think that's where they're saying they'll introduce a code of practice that deals with group grievances or collective grievances. Labour manifesto also refers to the introduction of a Race Equality Act to address equal pay, strengthen protections against dual discrimination, and that's on the ground of 2 protected characteristics, and root out other racial inequalities, as well as introduce ethnicity pay gap reporting for large employers. Penultimate section then relates to discrimination and diversity, equity and inclusion. In the area of equal pay, measures will be put in place to ensure that outsourcing of services can no longer be used by employers to avoid paying equal pay, and implement a regulatory and enforcement unit for equal pay with involvement from trade unions. This would be done in recognition of the fact that the current equal pay framework is inaccessible, for example, due to very long employment tribunal backlogs. Yeah, I mean, it's very difficult when somebody brings an equal pay claim or an equal value claim in the employment tribunal. It is taking years to go through. Large firms would be required to develop, publish and implement action plans to close their gender pay gaps and to include outsourced workers in their gender pay gap and pay ratio reporting. On 19th of June, Rachel Reeves stated her aim to close the gender pay gap if she is appointed Chancellor. Although Labour would prefer to work with employers rather than legally force them to close their pay gaps, Rachel Reeves also aims to increase the number of women on boards to 50%, currently 42%, and women in executive positions generally. Regarding gender recognition, manifesto provides that a Labour government would modernise gender recognition law to remove indignities for trans people. And then in relation to harassment, which we've already touched upon, it's a really big topic, harassment, because of the amount of claims that are going through the tribunal on it. They would look to strengthen the existing code, or the code that's due to come into, or the act that's supposed to come into force in October. So a real push on that. The legal duty for employers to take all reasonable steps to stop sexual harassment before it starts will be strengthened. Employers would be liable if they were informed of any sexual harassment and did not take appropriate steps or had not taken measures to prevent it in the first place. The legislation would also be amended to protect interns and volunteers against sexual harassment, which we've looked at. This is an interesting one. And it relates to maternity and menopause discrimination. The manifesto states, women's equality will be at the heart of our missions. Our plan to make work pay will transform the lives of working women, including by strengthening rights to equal pay and protections from maternity and menopause discrimination and sexual harassment. Because as we looked at, it never came in, menopause as a protected characteristic before. Large employers with more than 250 employees will be required to produce menopause action plans. And then guidance, including guidance for small employers, will set out measures to consider relating to uniform and temperature, flexible working, and recording menopause-related leave and absence. And then lastly, just a quick look at health and safety. The New Deal states that Labour would review health and safety guidance and regulations with a view to modernising legislation and guidance where it does not fully reflect modern workplaces. It specifically commits to modernising health and safety guidance with reference to extreme temperatures, preventative action and steps to enhance safety at work, and working with employers and trade unions to support the well-being of workers and their long-term physical and mental health, address whether existing regulations and guidance adequately support and protect those experiencing the symptoms of long COVID, and to ensure that health and safety measures reflect the diversity of the workforce. So there is a lot there, and some of it I haven't included because I've picked out the pertinent points. So that's what we're going to expect if a Labour government gets in.
Wow.
I appreciate
There's a lot.
there is a lot. There is a lot. So I appreciate I've gone over a bit. So sorry about that, Eloise.
No, that's absolutely
But there
fine.
was quite a bit to cover, as
Yeah,
usual, as usual.
yeah. There's always a lot to cover, but that's quite intense. There is, like you say, people are going to be busy. There is a lot of change, and I'm sure that's going to throw up some questions. But what I will say to everybody is, well, thank you, Keeley, for such an informative session. It's always a great session with you. You make it so easy to understand. So thank you. What we will do, everybody, is make sure that as the changes come in, we keep you updated. And if there's anything that is more complex, we will run sessions specifically on individual topics to make sure that everybody's protected and understands what the changes are. So, but as usual, feel free to reach out to me. I will send the slides and the recording out next week for you all to be able to revisit. I'll send them, Adrian. I'll send them to your email address because I've got your email address from logging into the event. So, but if anybody's got any questions that they want to ask, either myself or Keeley, I'll make sure that we've got our contact details on that email. Also, feel free to reach out to me if there are particular topics you would like us to cover. So thank you for joining us, everybody, and hopefully I'll see you at the next event.